Oh, there he is. Oh, no.
Matt Bruenig.
What a fucking nightmare. I had no idea this was going to happen.
Which side are you on? Which side are you on?
Matt Bruenig is is from the People's Policy Project, and he is a labor attorney. And last week he announced that he is taking Steven Crowder to court, so over alleged violations of labor law. So I said, wow, that is super in our wheelhouse. We have to bring him on the show to talk about that. And so that's what we did. I pre-taped this conversation with Matt yesterday. He was not able to be on the show today, so we pre-taped it yesterday. And let's go ahead and play that interview with Matt Bruenig. All right, folks, I am here with Matt Bruenig of the People's Policy Project and his new project, NLRB Edge, where he is going through the NLRB cases and kind of trying to make some of the legalese a little bit more palatable and understandable to normal folks because, you know, I think it has a really big impact on folks' lives, understanding the rights that they can have at work and being able to make use of them. He is recently kind of in the zeitgeist because he's bringing an unfair labor practice charge against Steven Crowder on behalf of a former employee, Jared Monroe. Stage name, formerly Not Gay Jared, no longer goes by that stage name. That's what he went by on the Steven Crowder show. And so wanted to talk to him about that. But before we get into that, I guess if you could give us just, a little bit more into NLRB Edge and why you wanted to do that project and some of the things that we can look for going forward.
Yeah, so NLRB Edge, NLRBEdge.com. Basically, before I was doing that, I was doing a lot of policy stuff, a lot of social benefits stuff at People's Policy Project. And that stuff has kind of, when Bernie Sanders was running and the first part of the Biden administration, that was a hot topic. A lot of people writing about it, a lot of interest. And that interest has kind of waned a little bit. And so I've kind of gone back to my roots, which was as a labor lawyer. And said, hey, let's do some NLRB stuff. The NLRB is doing a lot of interesting things. And then my other thought on that was there are services that you can follow that will kind of summarize what's going on at the NLRB. Those services are very expensive and they're targeted at lawyers. And so my thought was, well, maybe there's a niche here for people, regular people who are interested in unions enough that they might want to follow this. And I can make it simple, fairly brief. The little daily things I send out are not that long, and maybe reach a wider audience that could get use from this, that are not just looking to practice in front of the NLRB, but maybe use some of these insights in their own, workplaces.
Right. And I think that you do a very good job of making things easy to understand. I don't know if that's kind of just the way that you write or the way that you speak, or if that's a purposeful choice that you're making. But I've always thought that kind of the Chomsky model of, if you can't make things understandable to the average person, then generally speaking, people should be suspicious. And I think you do a good job of making things kind of understandable. So I think it's a great work that you're doing on NLRB Edge. And, for what it's worth, if people want to check out some of your policy stuff, it's still out there, and it is similarly digestible and easy to understand and very persuasive. So with that, let's go ahead and jump into the case that you're bringing against Steven Crowder. Give folks who don't know the story behind it, can you give us just the background on what was going on in this universe?
Yeah, so Steven Crowder, is a very famous right-wing kind of streamer, and he has 5.8 million YouTube viewers. He's kind of the big dog in that area. One story I remember from him, maybe a year ago or so, there was stories about him being upset that Daily Wire had only offered him $50 million. So
called it a slave contract.
Yeah, so that's that's where he is. Very prominent guy. But 6 years ago, he employed my client Jared Monroe as a producer on his show, and they parted ways. And after they parted ways, they entered into a separation agreement, which a lot of people do, sometimes called a severance agreement. And that separation agreement includes this clause that just kind of says, one, everything in this agreement is confidential, and two, sort of in the most broadest language, you cannot disparage Crowder or Louder with Crowder, which is his show. And there's no time limit on that. So in theory, he's supposed to have signed away his ability to say anything about Crowder for the rest of his life. But for 6 years, things, I don't know, nothing really came of it, I suppose, at least that particular clause. There was some tension between the two of them in other areas. But when Hillary Crowder, which was Stephen's wife, began divorcing Stephen after a rather viral video of Stephen, what would you say? Trying to make sure I don't say anything disparaging here, but berated her and said very, very negative things to her that she seemed to think was abusive. So she starts divorcing him. And then around this time, I guess Jared is friends with Hillary, Jared, my client. And, they maybe start talking just kind of as friends would do. You might reach out to someone if they were getting a divorce. And this has upset Crowder. And so he has brought this lawsuit claiming that Jared Monroe has breached this non-disparagement clause.
And so your argument then is, and there's a lot of things that could be discussed, I think, regarding the legal controversies between Hillary and Stephen, but I think we'll keep it pretty tight to the non-disparagement clause as it relates to Jared. Your argument is that clause is illegal and should therefore be nullified. And so explain that to us. How can it be that, Jared signed it, right? I mean, doesn't that mean that that's just, he signed it. So how can that not be valid?
Right. So under the National Labor Relations Act, Section 7 says that you have a right to engage in concerted activity for the purposes of mutual aid and protection. And that right includes, as long as you do it with a coworker, including former coworkers, criticizing working conditions, criticizing former managers, saying, this is a mean boss, this is a boss who mistreats you, whatever. You have a right to do that even as a former employee. And so any clause, whether it's in a contract, whether it's in a handbook, whether it's in an employment agreement, whether it's a company policy, whatever, they don't really distinguish. Any kind of rule that a regular person would read and say, oh, it looks like I can't do X, where X is something you have a right to do, that rule is illegal on its face. And if you bring a charge to the board, they will require the company to rescind that rule. And as far as, it's a contract. I mean, this kind of goes back from the very beginning of the NLRA. I think the case that they always cite on this is 1940 Republican Aviation. But a lot of what we're doing with labor regulation was trying to blow up contracts that employers would require their employees to sign. The most famous one, of course, the yellow dog contract, saying where you would agree not to join a union. So obviously if we start saying, well, anything you agree to is good to go, well, the employers would be able to make you agree to not join a union. And this is essentially the same kind of thing. Joining a union is something you have a right to do. Therefore, you can't waive that right, just as criticizing your boss, as long as you keep it focused on working conditions and with coworkers, is a right, and you can't waive that. So it's the same exact structure as that sort of yellow dog contract stuff, which I think people who follow labor in any capacity know about that stuff. So,
was Hillary also employed by Louder with Crowder at one point?
She was not, as far as I know.
And so then because the rule does not carve out an exception for talking about working conditions with employees, but it's a broad rule that says, you cannot disparage with anybody. And so anybody therefore includes former employees, then the whole rule is null. Is that accurate?
Exactly right. So it doesn't have to be that the specific thing that they're mad about is of a protected activity, right? The rule itself is a violation, just as if an employer were to say something like, now you guys better not unionize. I don't want you unionizing or whatever. Even if you never did actually unionize, the statement would be a violation of the NLRA. So it's a little bit of a creative move here, but basically you say, look, the contract, the clause itself is a violation of the NLRA, whether it's ever enforced at all. You don't even need a lawsuit. You could just bring a charge against that clause existing. The clause itself violates the NLRA. The remedy for that is to rescind the clause. If you rescind the clause, then of course you can't bring a breach of contract claim against it.
So then is there precedent for a clause being struck in its entirety by the NLRB over that was being acted upon for something that would in and of itself maybe not be illegal, like, because as I'm understanding it, and you know, I think you'll be able to help me, as I'm understanding it, it's not actually necessarily illegal that you know, NDAs I know are not illegal wholesale, right? And so you could have an NDA potentially that says, you know, Jared Monroe, you're not allowed to talk to Hillary Crowder, you know, you know, that would be the effect of the rule. That effect is not necessarily illegal, but the rule is, you know, encompasses things that would be illegal, and so the whole rule is struck down. Is there a precedent for the NLRB striking down a rule in that manner, where it's trying to be enforced for something the enforcement action would potentially be legal, and yet, you know, because it also restricts legal activity, the whole rule is null, and there can be no enforcement action based on that rule?
Yeah. So you're very sharp on this because, this is an issue they've had to deal with. There's a case called Double Eagle that kind of sets the rules on this. And conceptually, what you want to do is distinguish between two unfair labor practices. The clause is an unfair labor practice, and then the enforcement of it would be a second unfair labor practice. So the question you're asking is, okay, let's say the clause itself as it's written is an unfair labor practice. Okay, now, so that's one, you would win that, you know, but then they also enforced the clause, but the enforcement of it was not against protected activity, right? The activity that they enforced it against would not normally be protected, right? That's the situation. And there's this case called Double Eagle that deals with all that. Now, what's interesting in this case is, so normally that happens in the context of firing. Most of these cases are about firing someone. So in a situation where you had a clause, like a confidentiality clause, that was overbroad and therefore illegal, and then let's say some worker breached that confidentiality clause, but they didn't do it in the course of protected activity. They just shared some secret information about the company that had nothing to do with working conditions. What the board would typically do in that case is they would say, yep, the clause is illegal. You have to rescind it, but we're not going to reinstate the worker because the way that you applied it against them was not an application against protected activity, right? But in the case where we're dealing with a lawsuit, the premise of the lawsuit is that the clause exists and therefore you breached it. So if you rescind it, then the lawsuit can't continue, right? That's the basic theory. Right. So it's different than if you got fired. It's because the action itself needs the clause to exist for you to bring a breach of it, you know?
Oh, wow. Yeah. No, I think that makes sense. Is there precedent for that then? Is there precedent for, you know, the throwing out of a lawsuit on the basis of an illegal clause being struck down, even though, you know, the specific enforcement action may not be illegal?
Yeah, so there is a case that I'm aware of called Haynes Mechanical. The trouble with some of these cases is they settle, you know, so as soon as the writing's on the wall, they don't get to the board. But in that case, it went to the NLRB Division of Advice, which is where I used to work. That's where they put their little brain trust of lawyers to deal with tricky brain tingling questions like this.
Right.
And in that one, they had a confidentiality. No, was it? No, it was a coworker non-solicitation clause. So that these rules that say you can't try to solicit your coworker to go work for someone else. So let's say you quit the company and then you're like, hey, you should come work with me at my new company. There are rules that say you can't do that. Now, those rules are illegal on their face, according to the current general counsel. These things go back and forth, right? They're illegal on their face, but only certain kinds of coworker solicitation is actually protected, right? It has to be done in a certain way that relates to mutual aid and protection, right? So you had a case, like you're saying, kind of a perfect situation. The guy leaves, he coworker solicits, he does it in a way that's probably not protected activity. They bring a lawsuit against them. The lawyer in that case, who now works for CWA, but was a private lawyer at the time I talked to him, he brings the NLRB charge, does the exact same thing I'm doing, and the employer gives up. So the division of advice at the NLRB basically said that, yeah, this is how it would go. This lawsuit is illegal because it seeks to enforce illegal clauses. We would rescind the clause, blah, 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 everything I was just telling you. So it went down that way, but it didn't go up to the board. It settled before that point.
Hey, 5 seconds. Just wanted to say that this is only possible because of our donors. If you want to see more of this, then consider donating yourself at tvlr.fm/donate. I see. So that's fascinating. And so I think that the legal case there has been made. I think there's certainly a logical consistency at least, and I think I think that makes sense. But there are some law experts on Twitter that are not convinced, actually, of your of the case that you're making. I'm trying to see if I can find any of the names, and I'm not. Oh yeah, Robert Barnes.
Robert Barnes.
Yes.
Yeah. First time learning of him, but he's apparently kind of celebrity right-wing lawyer who kind of chases whatever the thing is. I remember someone clarified to me in the comments. They said, he just, what did he replied? He said, this is not what the law says or whatever. Mm-hmm. And, trying to explain to him that it is. And someone replied with, Robert Barnes, he represented Wesley Snipes, Kyle Rittenhouse, and 8 of the Covington boys. And it's like, okay, so this guy just.
And Ralph Nader.
And Ralph Nader. Okay. Yes, well,
Yeah. So, and as you pointed out, he's also an expert, apparently, on coercive rules under the NLRA. I've got this tweet up to right now. So yeah, I mean, how is it that you feel qualified to disagree with Robert Barnes? I'm not,
I did find that tweet really funny. It you don't want to, I don't come down too hard on regular people, though a lot of people on Twitter are not so regular. But what do people think like a good lawyer looks like? If you know anything about, I don't know, an actual lawyer, if you gave them that list of this person's credentials, one, of course, you'd say, okay, this is not a labor lawyer. But 2, you'd be like, this guy is, I don't know what he's doing. He's kind of a nut,
Yeah. Well, okay. So we're just we feel comfortable disagreeing with Robert Barnes is what I'm hearing, at least at the very least in this division of the law. So then how is it that Jared came to find you? Obviously you run in somewhat different circles, I think, than Jared does. Politically, certainly, you're not going to be a guest on any of his friends' podcasts, for example. At least not before
maybe
now. Right? Yeah, maybe now you will be, but before now that would have been a strange unless it was for a debate, right? You do debates sometimes. So how is it that you two kind of crossed paths? And then, because he's still conservative. So, him coming to a, socialist labor lawyer to take a case before the NLRB, which many conservatives kind of feel is, prima facie unconstitutional. How did this happen? And he become convinced that this is a good way to go.
Yeah, so he put up a 15-minute video on Twitter where he was trying to raise money for his legal defense because he had been sued and, needed these lawsuits are very expensive, and he explained his situation. And a lot of people contacted me based on his video saying, is this, like, this is something you do, right? Because one of the things that I had done just before this case was there were these radio hosts in Dallas, Texas, who quit their radio show and started a podcast, and they got sued for a breach of a non-compete clause and also for breach of non-disparagement and confidentiality and all that. That was in their employment agreement. And I represented them. I did the exact same thing I'm doing in this case. And within 6 or 7 weeks, the company settled, and that was that. So people recognize that. A lot of people email me, including one of the lawyers I worked with on that case, and we're like, isn't this the same basic thing? And I'm looking at it and I'm like, it looks like it is, so I contact him and I'm explaining to him, hey, I just did a case just like this, also in Dallas, which is where the case is taking place, in Collin County there in North Texas. I just did this successfully. So let's talk and let me show you like what I could do. And it went from there, and he, he signed up. And I mean, here's the thing, right? He got sued, so he's got to defend himself, so even if maybe whatever you think about unions or the NLRB or whatever, obviously you got to avail yourself of whatever you can to protect yourself when you're getting sued. Now, I mean, I've had conversations with him, certainly, and, right, just because you're conservative on some things doesn't mean you're conservative on everything. I think a lot of what animates the conservative movement right now deals with, I don't know, what do you call, like, wokeness or social justice or whatever. They're cultural topics. And I think they kind of will also pick up the economic kind of libertarian anti-labor stuff. But I don't know how committed all of them really are to that. Like, that's not really what drives them. And I kind of get that sense from Jared as well. It's sort of like, that's not,
right.
What, everyone has, right wing or left wing, the boss can still mistreat you,
Right. And that's one of the beauties of unions. I think, I'm a unionist in Alabama. So obviously, you have to have a pretty high level of tolerance for people with different ideas, as some people would say. So yeah, I'm appreciative of that. I'm trying to think. This is just such a funny situation. Has Crowder contacted you yet?
I have not heard from Crowder or his lawyers. I was told that, well, I'm still plugged. I don't really know too much about Crowder Universe, but I'm learning that he's got this lawyer who kind of appears on his show from time to time, that they refer to him as the half Asian lawyer. And he's in like some videos and whatever, and he kind of does their stuff. And his firm is the one that wrote the complaint in the lawsuit. So I guess the point here is, I don't think that law firm does NLRB stuff. So I'm wondering when I'm going to hear from Jones Day or whatever, or maybe they'll try to do it. I don't know. It probably would not be ethical to do it if you don't know what you're doing, but.
Well, all right. Well, I'm looking forward to watching the saga unfold, and I'll keep folks up to date on it here on our program. Is there anything else that I haven't hit on that you think that our audience might be interested in around this case?
Yeah, I'd have the spiel about non-disparagement clauses. I think, I'd like to get across to anyone who wants to hear it. But I think, the thing you pointed out at the beginning, which is sort of like, well, someone signed this, and, I can say, well, legally that doesn't matter. But I think it's also important to note that one of the problems with these clauses is, even if you sign it and even if you try to follow it, that doesn't prevent an employer who wants to be abusive towards you from bringing a lawsuit. And even though they might lose the lawsuit, it can still cost you tens of thousands, hundreds of thousands of dollars potentially to defend yourself. And so the clause is just this sort of like, this sort of ticking time bomb that if they want to, and anytime they can dip into it and just dump $10,000, $100,000 of costs on you, even if they lose. And when you have employers that have a lot of money, that's not a lot of money to them. They have to pay their lawyers, but it means nothing to them. It's a tiny percentage where that's your whole life savings. So the existence of the clause, even if you are cool with it, and even if you want to follow it, you can cross your employer in some other way, or your former employer in some other way, and then they can use this as leverage to hit you. I mean, this is actually, I think, a great example of this, because there's no evidence presented so far that Jared has disparaged Crowder at all. What he didn't like was it appears to me, I'll say my view on it from what I've seen, he had a nasty divorce. He didn't like that some of his friends maybe sided with the wife. And, that happens in divorces and breakups and whatever. People get mad, a lot of hurt feelings. Not a reason to be going into the courts and enforcing separation agreements about non-disparagement, but because it exists, it's a vector that you can use to achieve that. So, yeah, I think they're really bad. I would not recommend signing them. Because even if you're cool with it and you're like, I love my boss, I'll never say anything negative about him. You never know.
Right. Yeah, that's exactly right. And that's one of the, just generally, I think that's one of the arguments that we have about the importance of unionization and that balance of power in the workplace is that, people say, oh, well, if you've got a good workplace, you got a good boss, you don't need a union. And it's like, well, your boss could die. Right, like tomorrow, and then you have a new boss, and who's to say that this new boss is going to be the same or different, in some radical way. People change, right?
It's good. It's good until it isn't, and also your boss is me. They've got to answer to their boss, and they're gonna, so. Yeah,
exactly. Yeah, it's never great to have just weapons laying out there that can be picked up and used against you at any time, and so especially where they so radically kind of cross with very many people's sensibilities of what seems right. Like I think most people kind of do feel like I have some sort of right to speak freely about, the conditions of my employment or how I feel about a person. And so, just in general, I think that people can kind of get on board with the destruction of these NDAs. There's been conversations in the Biden administration about the, really either abolition of those as a legitimate form of contract or drastic scaling back. Where are we at with that? Or do you may not be following that. I don't know. No,
I mean, I think the non-compete clauses are a big area. NDAs themselves, I think, the NLRB certainly is pushing their angle on it. But, that is limited, and you could write an NDA that wouldn't cover that. As far as, on the federal level, you'd have to pass a law, I would think, in order to make it to where NDAs were unenforceable. There was I don't know if this was there was a law that was passed a couple of years ago about mandatory arbitration when it deals with sexual assault. And a lot of that had to do with NDAs, essentially, right? Because what would happen was employers would force you to bring kind of like sexual harassment claims in arbitration, and then that would be locked down and you couldn't talk about them. And so they kind of blew that up, but that was very narrowly focused on that. But yeah, I mean, the idea that you're going to pass a law blowing them up probably seems pretty improbable now, especially with Republican control of Congress. So the NLRB angle is kind of the angle of the moment. At least if it's in an employment contract, it's always worth checking to see if maybe there's a way through the NLRB to get it invalidated.
Would there be any concern about, the federal courts overturning an NLRB decision on this? Is this, does this feel to you sound enough ground that even, the kind of conservative judiciary would uphold the ruling?
Yeah, so for employment agreements, if they're in an employment agreement, that has there was a case called Lutheran Heritage that was from 2004, so that would have been Bush board that set the rule that would have made these things illegal in employment agreements. And that was upheld by court after court after court, even the Fifth Circuit, which is the most conservative court. That got switched. Lutheran Heritage got replaced by this case called Boeing. And then now it's gone back because there's a case called Stericycle. So where that happens at the board, it'll flip back and forth. But that rule, the rule we have now, which is the Stericycle rule, was the Lutheran Heritage rule, and the Lutheran Heritage rule never had any problems in the circuit courts. Now, there is a question, I guess you could try to argue that severance agreements and separation agreements are different from employment agreements because these are like post-employment agreements. In my mind, there's no difference. The current board law is that there's really not difference. And it doesn't really make sense for there to be difference because the word employee, which is the people who are protected by the act, also includes former employees, and that's been recognized by the Supreme Court. So, you never know. You never want to be too bold with these things because sometimes courts just do whatever they want to do. But logically, consistently with sort of the framework of this law, it would be quite a thing to come in and say, well, not for this particular separation agreement or whatever,
Right. All right, Matt Bruenig, NLRBEdge.com. Appreciate your time. I enjoyed it.
Thank you.
You just saw a clip from the Valley Labor Report. We are live every Saturday morning from 9:30 a.m. till 12:30 p.m. And we pride ourselves on keeping all of our content free to everybody so that we can talk to as many working folks as possible. If you support the work that we're doing, you think that it's important, you think that it's good, then consider making a monthly contribution to the project, and you can do that on our website, tvlr.fm.